I will call this meeting to order. And as you will recall from our last meeting, Mr. Barrett has the floor.
Well, thanks, Madam Chair. And to pick up where we left off, I was speaking about the necessity of this committee to undertake a study of the Trudeau report, too. And I think that to advance this, and so that we do have everyone on the same page, I'd like to describe the sequence of events, the timeline that's led us to this point. And we saw, and this comes out of statements from the Prime Minister that in 2015 that we would have in the Liberal government a government that was open and transparent by default. And instead, on the very day that this story first broke in February of 2019, the immediate response was that the story was false. And then in subsequent months, we heard again, time and time again, that the Prime Minister did not pressure former Attorney General Miss Wilson-Raybould. And we know that to be not true. We know that that was not an honest statement. The story, you could say it evolved, but it changed. The story changed throughout the months that followed the revelations in February of last year. And it was, as it evolved, it went from being false to being, the cabinet shuffle was the result of Scott Bryson resigning. Then we heard that it was Stephen Harper's fault, and then we heard that it was about jobs. Now, the jobs refrain was one that got locked in, and we heard that over and over again. But the only reason the Prime Minister undertook the sustained campaign of political pressure by on Miss Wilson-Raybould was in the name of re-election. It was because of the general election that was planned for October of 2019. Now, even after the Ethics Commissioner released his report finding the Prime Minister guilty of breaking ethics laws for the second time, the Liberals continued to block the investigation into the scandal at every turn. But I want to give the opportunity with this new motion to give all members of the committee, to give Liberal members who share benches with their cabinet colleagues, to give all opposition members, my colleagues in the Conservative caucus, the Bloc Québécois, and the NDP, the opportunity to give Canadians closure on this issue. We saw the report from the Conflict of Interest and Ethics Commissioner, and now the Commissioner, has not reported back to this committee, and that's essential. We also heard that the government had confidence and trust in officers of Parliament. Regrettably, though, we know that full transparency wasn't granted during the investigation, and that obstruction continued in that process. And I expect that my colleagues on both sides of the House would agree that we want to have a Parliament for Canadians where they know that the truth will come out, and that should be a strong deterrent for bad judgment or bad behavior. But using certain rules that ought to protect strategy or issues of national security, public safety, that would necessitate secrecy in government. One can appreciate those, but for political reasons, nakedly partisan reasons, Canadians expect that when an investigation is undertaken by an independent officer of Parliament, that they're given unfettered access. And if there's a reason to invoke secrecy requirements, that there be an off-ramp for that officer of parliament to review the information, determine its relevance, and then the reportability of it to committee and then to Canadians be considered on a case-by-case basis. Now, last year, in February of last year, February 12th, there was a letter sent from opposition leader Andrew Scheer to Prime Minister Trudeau. And it said, and I quote, "I call on you to immediately waive solicitor-client privilege in respect of any advice given to you or your staff in relation to the prosecution of SNC Lavalin. Additionally, I call on you to also waive any and all rights to confidentiality in respect of communications to or from yourself or any member of your staff, previous or current, in relation to the prosecution of SNC Lavalin." And it goes on to say, if you do not meet these obligations, Canadians can only conclude that there is something that you wish to keep hidden. This is from the outset last February. While the position of the government has evolved, our position has maintained, we've maintained the same position, and that's that we want transparency, we want openness, we want accountability from the government, and that's what Canadians expect. And it continued on the Justice Committee in 2019, when in an emergency meeting of the committee, at the time I was a member of the standing committee, opposition members were blocked by the Liberal members of the committee in their first attempts to shed light on this scandal. And so we from the outset on that committee, we saw that government members quickly fell in line with the government, and we, of course, persisted, because that's what we heard from Canadians loud and clear. From coast to coast to coast, we heard phone calls and saw letters pour into our offices. Certainly they did into mine, from people who demanded more from this committee, from this Justice Committee. In February, on February 20th of last year, there was an Opposition Day motion put forward by the third place party, the NDP, and they were looking for an inquiry. And this motion calling for an inquiry was.
I'm listening very closely, and I just want to clarify. He said that it was from the NDP. Does he know the member who brought forward that motion for an inquiry?
Madam Chair, I believe the member was Mr. Angus. Timmins James Bay, is that correct?
Timmins James Bay, yes. Thank you. I just wanted to have that on the record to clarify.
So the member for Timmins James Bay wisely put forward, was the sponsor of an Opposition Day motion calling for an inquiry into this issue. Conservative MPs supported it, NDP members supported it, and even two Liberal MPs supported the motion. And until then, Canadians were told the Justice Department's decision not to award SNC Lavalin a deferred prosecution agreement came weeks after Prime Minister Trudeau met with the former Attorney General. Well, then we learned that meeting occurred 2 weeks after the decision was made. We know that in that meeting, the Prime Minister reminded Ms. Wilson-Raybould that the final decision on SNC Lavalin's deferred prosecution agreement was hers to make. The decision had already been made, Madam Chair. The Prime Minister's reminder to Ms. Wilson-Raybould was direct pressure to intervene in the prosecution. We saw on February 25th of last year a Conservative Opposition Day motion to call on the Prime Minister to testify at committee. And that motion said that given the Prime Minister's comments of Wednesday, February 20th, 2019, that the Standing Committee on Justice and Human Rights is the appropriate place for Canadians to get answers on the SNC Lavalin affair, and given his alleged direct involvement in a sustained effort to influence SNC Lavalin's criminal prosecution, the House order the Prime Minister to appear, testify, and answer questions at the Standing Committee on Justice and Human Rights under oath for a televised 2-hour meeting before Friday, March 15th, 2019. The Liberals defeated the motion reaffirming their commitment to a cover-up. Fast forward to March, Madam Chair, having Ms. Wilson-Raybould return to committee. Now, she had said in her testimony that she had more to say, but we know that the waiver that was granted to her was not sufficient for her to give the totality of information that the committee was looking for. Now, she said that she couldn't answer direct questions regarding meetings and interactions after she was fired, and she acknowledged that they were relevant. And Canadians heard the testimony and saw Ms. Wilson-Raybould testify, and it was compelling, to say the least. But again, we were thwarted in our attempt to get the full information. And I want to, as I move through this timeline, I want to go back to that February letter from Mr. Scheer that just called at the outset for a transparent approach in responding to this. And almost certainly that would have limited political damage, which was what gripped the PMO for much of last year. But it also would have given Canadians the confidence that they deserve in public institutions, and that is what's so important. On March 19th, the Justice Committee, March 19th of 2019, the Justice Committee held an in-camera meeting, and following that meeting, we know that that the attempt was made for the committee to be shut down on all further efforts to probe the scandal. The Liberal members of the committee stated that no witness was prevented from providing evidence on any relevant information during the period covered by the waiver. But again, we know that that is not the case. Not letting Ms. Wilson-Raybould give her full testimony was the largest impediment at the time. Now, further directing members of committee to close down the investigation was, I guess you could say, adding insult to injury. On March 26th, Liberal members of the committee blocked a push from opposition members to open a new probe to invite the former Attorney General to testify. MP Peter Kent presented a motion to the committee calling for it to study the allegations, asking the Prime Minister to waive further privilege and allow Ms. Wilson-Raybould and others to speak openly on the matter. The motion also asked that the former Attorney General and her colleague, the former Treasury Board President, Ms. Philpott, appear before the committee, and then the committee present its findings to the House. Now, fast forward to August 21st. The Liberal members rejected a motion to have the Ethics Commissioner appear at the Ethics Committee. The motion by the opposition to have Commissioner Dion testify was defeated 5-4, with only one member breaking from the majority, and that was one of the members who voted with that first Opposition Day motion, MP Erskine Smith. Now, in addition, an additional motion by the NDP to have the Prime Minister testify himself, along with the Minister of Finance and his former Chief of Staff, Ben Chin, was also defeated. We saw in September, Madam Chair, that attempts at an RCMP inquiry into potential obstruction of justice was hindered by the government, and a waiver of confidentiality was not provided by the clerk of the Privy Council, nor did the Prime Minister override the clerk, which would allow the RCMP necessary access, when conducting an investigation to both staff and materials. The so close to the beginning of an election, though not surprising, it was disappointing to see the continuation of what at that point was a full-blown cover-up. So we had an election, and in the election, the issue was raised more than one time, including by myself. And this issue appeared in the party platforms, gave rise to material in the party platforms for members sitting at this table. And we have many opposition members. We have 121 in the official opposition alone who ran on a commitment to look at this issue. The same is true for the NDP. So Canadians didn't approve of the conduct that took place. I don't believe that voters who elected Liberal members would simply discard the good work, the potential good work of their member, and throw them out of office because of this issue. But there was an expectation. They did hold an expectation that with a minority government, with parties collaborating, working together, with the official opposition, a strong official opposition, receiving a record number of votes, committing to examine this issue, that it would be examined. Of course, it also stands to reason that the independent officer of Parliament who undertook the investigation and duly made his findings, that he would have the opportunity to present those at committee. So to come to committee with the motion that I have presented, it gives all members an opportunity to deal with what for some may be an uncomfortable situation, but it's necessary for us to deal with. And in presenting this new motion, there's a critical element to it, and that's that it's time-bound. And so this isn't going to be what we preoccupy. I don't aspire to talk about this issue for 4 years if that's the duration of this Parliament. I don't. I would like to deal with it and to move on. I read following the last meeting comments by my colleague Mr. Fergus that Canadians don't want us looking in the rearview mirror. If that's a fair characterization of his comment, I'm sure he'll correct me if I'm wrong. And to a point, I'm inclined to agree. However, we're not looking in the rearview mirror. This issue is still present and it's front of mind for many Canadians. They genuinely want to have confidence in what we do here. We don't want the representatives of the 338 ridings that make up Canada to be referred to in a, we don't want the term parliamentarian to be a pejorative term in Canada. We want Canadians to know that the conduct here, our conduct here, is beyond reproach. And when we have an investigation that reveals and validates so much of what we heard during testimony at committee last spring, but isn't able to drill all the way down and to get all of the information, Canadians are left wondering. They're left wondering if the cries of cover-up were just partisan tomfoolery, or in fact was this a sustained attempt, a coordinated effort to cover up the rule of law, the obstruction of the rule of law in Canada, and that should give Canadians great pause, and it has. And I would be surprised to hear from colleagues that it's something that has not been raised with them in the last year. I certainly, as I mentioned before, heard about it many times, and I think it also bears mention, or it's worthy of mention, that following the commissioner's report what we didn't hear. And so there was recognition that the investigation had occurred and that there was a finding of guilt against the Prime Minister, but there was no apology. And the refrain that he'd never apologize for standing up for jobs, to paraphrase. I know from my interactions with people in my constituency, but with many Canadians, that's insufficient, and that it's an aggravating factor in why I believe that there is public desire and there is it's in the public interest that we finally set a date to finish this thing. We hear from the commissioner on this thing. We take a look at it, and we report out on the subject. There would be a majority report, there would be a minority report, but then Canadians know. And does it then inform this committee on good future work to do that would serve us well under a government of any political stripe? The relevance and the importance of officers of Parliament is tied directly to their ability to do their job. And if we have a structure set up where they're unable to do their work because, well, it might that might embarrass the government of the day, well, that's going to leave a majority of Canadians dissatisfied with the institutions that they're paying for. We have the Conflict of Interest and Ethics Commissioner, and we have the code that governs members. It's critically important that we have a robust code, and that I believe acts to guide members, and that we have the Act. And when the Act is strong, and when we have a commissioner who has all of the tools in his or her toolbox to ensure that it is being followed, and to investigate complaints or allegations that it has not been followed, and that there's also real consequences available when it is not followed. That is an expectation that we have. That's what I know my constituents expect if there is a Liberal government, a Conservative government, an NDP government, or other. They expect that they can have confidence because it doesn't matter who has the keys to the PMO. We have someone who's going to be a check on the balance of power other than another political party, other than the official opposition or opposition parties. It's going to be the independent officers of Parliament. Just like we won't, we would find it, a very cynical move of a government to cut the funding from the commissioner's budget because we don't want them investigating, the government of the day. I think it stands to reason that the same can be said to be true when we uncover the fact that the rules that are in place neither provide adequate guidance, nor do they provide adequate deterrence when the rules aren't followed. And that's what we can gain from hearing from the commissioner on this specific issue. This committee is not going to issue a finding of guilt. That was done. That was done already. But what this does give us an opportunity to do is take a look at, to hear from the commissioner, and by the time I finish, will I have need or opportunity to stretch out that hearing? No, I'd get the same amount of time in questioning the commissioner as is allocated in the rules of this committee, and then we could undertake the good work that that only members can do to improve the tools that are available to the commissioner and that Canadians expect that are in place to keep us honest. So, Madam Chair, it's a unique opportunity that we have in front of us here today. We have the opportunity to dispel the cloud that hangs over us sometimes, that we can't break free from partisanship or party whip, but that we can move forward with an agenda that satisfies the public interest, that satisfies a real need that's been created. And I can't underscore enough the number of times that we've heard from Canadians, and even in recent days, there was coverage of our proceedings before the break, and I got a lot of feedback about that, and I think that speaks volumes, that the opportunity that we have to cauterize this and restore confidence in our public institutions for Canadians. It's a rare opportunity that we have. And I know that so many facets of our system, of our parliamentary system, are very special, and they serve our country well, and they are the envy of truly they're the envy of the world over. You know, many countries don't have the type of democracy that we have, and don't have the checks and balances that we have. And this committee is one of those checks and balances with the commissioner. This gives us that opportunity. And so when considering how they're going to vote on the motion, I implore members to give due consideration to the opportunity that's presented, and different than the first. Different in that it's time bound, and that's part of, you could call it an olive branch, if you will, that I'm looking to reassure members that we can address the issue and move on. But if we don't address it, that is, and we don't hear, and we don't have a proper review of the Trudeau Report 2, that's when we leave that void, where the lack of public confidence comes in. That's where people refer to being a politician as a pejorative term, and we get lumped in with lawyer jokes or something else like that. That shouldn't be the case. This is honorable work that members do in this place, and it's so important. And there's great tradition that comes with it. And here we each have that opportunity today to deal with what Canadians have told us. And they told us that in ridings across this country. Not only were they elected opposition members, but in ridings where Liberal members were elected as well. There were votes cast for the parties who put forward platform items specifically on this issue. It's so rare that would happen, and I look forward to having many opportunities to find common ground to stomp on with my colleagues on all sides of the House. But I think on this issue, and I think on this issue that it would show that spirit of collaboration that is referenced in committee documents. It would show that spirit of collaboration that we heard from so many that would be taken to heart after the election. And I'm just going to ask if there is a copy of the motion handy, and while we dig that up, remind everyone that we don't know how long we're going to be here for. Not today. Today, I imagine we'll be done at 5:30. But I don't know how long this Parliament is going to last.
Point of order. Are we getting into theology here? Because I plan on living a long time, and I get very worried when someone says I have to move on a motion because I might not. Are we talking about Parliament, or are we talking about life?
Parliament, sir.
Okay, good. I just want to clarify because I plan on living for a little while longer.
Sure. And so, Madam Chair, I'd like to read my motion. I believe that it's going to be circulated, and it was read into the record at the start of my remarks. And I would like to I know that there's a speakers list, and so I'd like to give the chair the opportunity to recognize my colleagues who've asked to speak, and I am conscious of the fact that we do have the lobbying commissioner. She's expected in 25 minutes, and so I want to be respectful of that, and so I'll read my motion in English, and it's provided in both official languages. That the committee commence a study on the report by the Conflict of Interest and Ethics Commissioner entitled Trudeau 2 Report, published on August 14th, 2019. That the Conflict of Interest and Ethics Commissioner be invited to appear for no less than 2 hours to brief the committee on his report, and that he be given 20 minutes for a prepared statement, followed by questions from committee members. That the committee invite other witnesses as required, and that the committee table a report in the House of Commons no later than May 29th, 2020. Madam Chair, like I want to be mindful of the time that we have in this committee. I hope that I'm demonstrating that by bringing my remarks to a close in just a moment. I'd like to again underscore that May 29th date, that I'm not talking May 29th, 2023 or 2024, this year, this spring. Let's put this issue to bed because it has not been. We have a report from an officer of Parliament who has not reported back to the committee on this issue. So we have that opportunity to deal with that today, and I look forward to hearing from all colleagues on this issue. And when you do come to call a vote, Madam Chair, I just ask for a recorded vote at that time. Thank you very much.
Thank you, Mr. Barrett. Based on my speaking list from last day, I have Mr. Angus.
Thank you. I'd like to thank my colleague for bringing forward this, the Officers of Parliament report to this committee. That's our work, and we have to hear from them. I was very disturbed in the previous session that we did not hear from Mr. Dion on this. His report raises a number of troubling questions that require answering. One of the things that my colleague did not speak up so much about, but for me is where I'm really interested in, is Mr. Dion saying that he was interfered with in his work. That's not acceptable. Nobody in the Prime Minister's office can tell Mr. Dion he can't investigate, because we can't then have credibility if there's a politically hot button issue. We have to trust that the Office of Parliament have the tools to do their duty, and if they're being denied that, it comes to us to address that. There are many outstanding issues on this file, and this came at an enormous cost for the credibility of the Canadian government. We lost the head of the Privy Council, the Prime Minister's Chief of Staff, two of his most respected cabinet ministers. We were put on the watch list internationally on international bribery and corruption because they felt that if we do not have standards for independent prosecution of corporate crime, what does it say about Canada? I guess my concern would be how many meetings we're talking about, because I know my colleague has said he's being very judicious of the time, but it has taken about an hour and 2 hours to explain the basic principle. So I'm not interested in an open-ended committee. I feel there are a lot of unanswered questions, but some of them are just going to, in the interest of what we do with our committee, I certainly see that Matthew Bouchard from the Prime Minister's office should come before us. Ben Chin should come before us. I don't know if it's fair to ask Ms. Wilson-Raybould in her position now, but I those two witnesses, maybe Mr. Butts. I heard from Michael Warnick. He spoke the last time. I felt he didn't do his position with much credibility, but definitely Mr. Chin and Mr. Bouchard, because they were key in setting up meetings that put the Prime Minister in a situation where the Prime Minister was found guilty of attempting to influence, to aid the financial interests of another party. And as public office holders, and their present public office holders, I think they are obliged to meet that high standard. So since they are still public office holders, I think they should come. So I would like to hear from my colleague in terms of how many meetings, because I think if we have Mr. Dion for one meeting and then we have these witnesses for the other, we could do it in 2 meetings, and then we would be able to present a report to Parliament that I think would close this chapter. We would be seen doing due diligence. I know it's hard for the government to have this issue dragged up again, but when a report of this magnitude comes before us, we have the obligation to hear the commissioner and to follow his recommendations and to test him on how he undertook that investigation to make sure that he did due diligence, which when I read it, I feel he has, but we should have the opportunity to look at this. So if my colleague has interest in a witness list, that would reassure me in terms of how many meetings he wants.
Mr. Keurig, you are next on the list.
Certainly, thank you, Madam Chair. I would be prepared to yield my time to Mr. Barrett, and you could come back to me. I know that there were some questions posed by my colleague from the NDP, and certainly I'd be happy for you to come back to me if that's acceptable.
So I'll go to Mr. Barrett and then I'll return to you.
Thank you.
Thanks, Madam Chair. Through to Mr. Angus. I think that his proposal is reasonable. As far as the witnesses that he mentioned, I think that it would be their testimony would be more than germane. It would be critical to this study. But again, and to your point, and well taken, that I did speak at length in the preamble. However, I do think that 2 meetings, but not more than 3 would suffice. Once all parties had collaborated in camera on witness lists, if that's the will of committee, and then those deliberations would the output would be the number of witnesses, and I think that proposal is eminently reasonable.
Mr. Keurig.
Thank you very much, Madam Chair, and it's an honor to be able to talk about this subject in particular, because I think it strikes at the very core of who we are as parliamentarians, the very core of who we are in our country, and representatives in the Parliament of Canada. And I'll talk a little bit more at length about that, but I would like to just note and thank the clerk for her work to organize a committee room with television cameras. I know I had mentioned that I would bring it up whenever necessary, so I do want to thank the clerk and the folks that do the hard work to make sure that MPs can do their job. So thank you to the clerk and the other staff that help make this, and it speaks to the fact that we're on television. Speaks to accountability and the accessibility for Canadians to their democratic institutions. And certainly the motion that we have before us, I think, is entirely appropriate. In fact, it's absolutely necessary to deal with what has been a true shaking of the trust in Canada's democratic institutions. When I, having run for the first time in this past year, I heard this issue, the concerns regarding the actions of the Prime Minister. I found it quite stunning, actually, that there were things like deferred prosecution agreements, DPAs, and the Public Prosecution Service, and cabinet confidence. These are terms that are not generally in the common discourse of Canadians, but they were in the past election. They were in the approximate 8 months since this story broke in the Globe and Mail at the end of January. These words, these terms that most Canadians, and I can say this because I spoke to thousands and thousands of Canadians over the course of the campaign, it was not something that they generally cared about, not something that concerned them with their day-to-day business. However, when our democratic institutions are put at risk, when the rule of law is questioned, when you have a prime minister that says that he is standing up for jobs, yet certainly in my home province of Alberta, it seems like the very opposite is true. and a very, very troubling trend. And the conversations, whether it be the recordings that were released, the testimony, quite striking. You know, I often joke that that when the viewership of Parliament must spike after new MPs are elected. I know my family has commented that they've never watched CPAC as much as they have in these past number of months. But I know for a fact on the day that the former Attorney General went before the Justice Committee, that eyes across this country were glued to the television, because the very hallmark of the independence of the Canadian judiciary, the rule of law, our democratic institutions that protect us from governments overreaching, from the ability for corporations or individuals to buy influence, all things that this committee has a unique responsibility. We're going to be hearing from the lobbying commissioner later today, and the fact that we are able to have a system that by and large makes sure that we are protected from interests that would attempt to persuade unduly and disrupt the functioning of our institutions is absolutely fundamental to who we are as Canadians. And I would encourage all members, and I'm a big fan of parliamentary democracy in general and the history of it. And I think that one of the things that makes our democratic institutions, and specifically Canada's Parliament, so powerful and so unique, is that the House of Commons is made up of, at this point in time, 338 independent constituencies that elect a member. And the qualifications of those members, it varies from coast to coast to coast, but ultimately it's the person who gets the most votes, who's given the confidence and the trust to enter this chamber. And sure, I'm sure every member sitting around this table who has been on the ballot can attest, when you first walk into that chamber with the confidence of the people of your constituency, it is an incredibly humbling thing. The fact that our institution, 338 MPs, get to join together. Now, how does a government get formed? Well, you must have the confidence of the House. Now, that's easy in a majority. One party makes up the majority of those seats. In a minority, it gets a little bit more complicated, but the principle remains. And there is, whipped votes and all of these other things. But when it comes down to it, each and every one of our 338 MPs stand for their constituencies. And the reason why I emphasize this here today is because the fact that some of these questions regarding the Prime Minister's actions and the actions of some of the most powerful political staff in the country call into question the role of our institutions. It is absolutely fundamental that we are able to address this, and the fact that the Conflict of Interest Commissioner put together a report, did the work that's required on his end to attempt to answer these questions, and then the mandate, and having read through the mandate and being appointed to this committee, that we have to hold those officers responsible to ensure that the tough questions are asked, whether we're in the opposition benches or whether we're in the government benches. All as MPs, we have the responsibility to ensure that the tough questions are asked. Now, the Conflict of Interest Commissioner did his part. Now, it's time for members of Parliament to do our part. It is clear, and I know the Trudeau 2 report, and I have it here in front of me. It leads almost a little bit too much like a novel. And I know my colleague used the word cover-up, and time again, there's just outstanding questions, whether it be related to cabinet confidence, whether it be the question around who benefited from the influence, the fact that and I would read on page 2 in the executive summary of the Trudeau 2 report. the second to last paragraph reads this, and I'd like to read this into the record if I could. For these reasons, I found that Mr. Trudeau used his position of authority over Ms. Wilson-Raybould to seek influence, both directly and indirectly, her decision on whether she should overrule the Director of Public Prosecution's decision not to invite SNC-Lavalin to enter into negotiations towards a remediation agreement. And then, in conclusion of the executive summary, he says, therefore, I find that Mr. Trudeau contravenes Section 9 of the Act. You know, I think that as you continue to read through this, and out of respect for the committee and the important business that we have, and I know I have questions for the lobbying commissioner that is going to start in about 10 minutes. Out of respect for the good work that this committee is doing, I did want to ensure that we have the opportunity to lay and as I conclude, and those who would have, and I'm sure there's nobody in this room that was at any of my campaign events, but I talked a lot about the principles of good governance, and the reason why I do that, Madam Chair, is because there are certain things that transcend politics. You know, there's distinctives for, you know, Liberal members, NDP, Bloc, Conservatives. There's distinctives that make us, you know, and we all, I'm sure, have reasons that we belong to certain political parties. But there are certain things that transcend politics. And this, I would submit to all colleagues around this table, is one of those things that transcends politics. The accusations, the evidence presented, and again, to use the word that my honorable colleague used, the fact that there's even a conversation around a cover-up speaks to the exact reason why this issue is not closed. And Canadians, I believe, need, in order to preserve the very institutions that we all have the honor and privilege of being able to serve and protect, Canadians deserve their parliamentarians. For me, the good people of Battle River Crowfoot and all of our respective constituencies. They deserve to have these questions asked and answered by those involved. So, Madam Chair, with that, I would bring my comments to a close, but I do implore each member around this table to consider how this motion moving forward or not, because we all have a choice to make, and there are consequences to those choices, how that impacts the very job that each of us was sent here to do. Thank you.
Mr. Fergus.
Merci beaucoup, Madame la Présidente. Puis moi, j'ai juste...
Thank you. I have a simple question. And I would like to know, is this motion in order, given that it looks a lot like the first motion that was moved and that was rejected by the committee 2 sessions ago?
So, Mr. Fergus, if you're asking to have a ruling, you would be welcome to raise a point of order. If you're simply looking for a discussion, then I can respond in the moment.
Alors, si je peux avoir, Madame la Présidente.
Madam Chair, if it's possible, we'd like to have your ruling on this. Is this motion in order?
Okay. So you're asking for a ruling. Excellent. Thank you. I can take discussion on that, correct? Before I... So on a point of order, I will make a ruling on that, which is not subject to discussion. And so my ruling on this, I have had to think about this, is that it does fit. The reason I would say that is because when I look back, when I look at the documents that I'm presented with, and they are somewhat limited, I'll admit that. It is not easy for me. There is a gray area here. So I am given this to work with. As chair, I am asked to rule whether or not it is of sufficient variance. That is the quote, the term used. And I've had to wrestle with this term, sufficient. It's not substantive, it's sufficient. And so if it were substantive, then I would look for a difference in substance. But it's sufficient, which gives me two words to work with. I have to look at the purpose of the motion, and I have to look at the means by which the purpose is fulfilled. And so when it comes to the purpose of the motion and the means of the motion, one of these can be the same, and one of these can be different, and the motion is still declared sufficiently variant. So in this case, I would say that the purpose of the motion is the same, to bring forward the Trudeau 2 report, but the means by which that is met is different. Where the first motion asks for the law clerk to come forward and for the cabinet confidences to be the point of discussion, the second motion does not include that as a means. Furthermore, in the first motion, there is no time limit given, which means that the means are unending. There's no limitation to it. Whereas in the second motion, there is a set, or it sets an immediacy to it, or gives a very tight time frame, asking for the study to be completed and for the report to be written and given back to the House by May 29th. And so given the fact that the means are different, though the purpose is the same, according to the House of Commons debate, one that I'm given to look back on that took place in 2006, I would rule this in order. Sorry, Madame Goodrow.
Je vais parler tranquillement pour vous.
I will speak slowly so that you're able to understand the interpretation. Thank you to the interpreters. You do a great job. I will respect our invited guest because I also would like to speak for a very long time on this issue. I don't know who listened to my speech this morning, my 10-minute speech, on the motion that was tabled today. The bloc is for this, of course. We want to know what really happened. We want to have all the elements, but what is our role as a parliamentarian? And I'm speaking on my own behalf. And today what I was mentioning this morning is we have to be fully aware that we are working here for the Ethics Committee. And what is the issue of morality? It's to look at an issue, to discuss on good, on bad, on moral issues, to go forward. And we've been hearing this for many weeks. I'm not making anything up here. And now my conscience is telling me that I was elected. I was elected to spend this money and spend all this time to go try to obtain information, to beg for information, when in the end, this is the committee. We have a law for the access to information, and this should allow us to get to the bottom of things. What's going on? This is going on for a long time. I feel that this is partisan politics at play, and I've decided to accept this committee because we would talk about ethics, talk about the protection of personal information. 30 millions of Canadians saw their identities stolen. Where is your impetus to act as parliamentarians? I only have 1 minute left. So today here we are working in an ethics committee, and I want us to work in an atmosphere of respect. I've been respectful. I've been listening to you, and I think this has to be on all sides, and also for our taxpayers, for our 37 million people. And this, well, I'm a new parliamentarian. I have a lot of things that I need to learn, but I can't wait 3 years to say things the way they are. And I'm repeating this, and I'll end on this note. We are sitting here on a committee. This is a standing committee that works on access to information through our motions and acts on access to information, the protection of privacy and personal information. This has a huge impact on our lives, on all our lives, and ethics. Thank you for having listened to me. You know how I will vote and what's important.
I thought perhaps I saw some hands up here earlier. I just want to make sure that they didn't get missed. You guys are good? Awesome. All right. Having heard from everyone, then I will call us to vote on the motion that is before the committee. Now, before doing so, I just want to take a moment to actually caution the members, and that is this. Based on principle, I have voted, or I have ruled this motion in order. However, let this caution stand. If this motion, or a motion like it, were to come forward with simply changing a date, I would have no other choice than to rule that out of order. At that point in time, it's getting silly. And so just putting that out there as a caution to the committee, that there does have to be sufficient changes made to motions in order for them to come forward. With that, I will proceed to a recorded vote.
All those in favor on the motion of Mr. Barrett, please say yay when your name is called. All of those against, please say nay when your name is called. Madame Brière. Mr. Dong. Mr. Fergus. No. Mr. Anandan Sangari. Ms. Shanahan. Nay. Mr. Barrett.
Yay.
Mr. Gould.
Wait.
Mr. Couric.
Yay.
Madame Gaudreau. Mr. Angus.
Okay, thank you. So the motion fails with 6-4. At this point in time, I will suspend and we will get prepared for our first witness. So let me call the committee's attention to a quick order of business before I formally invite Ms. Belanger to give her remarks. We have a subcommittee report before us, and I would just look for agreement to adopt the subcommittee report. Yes?
Yes.
Awesome. Thank you so much, everyone. Ms. Belanger, thank you so much for coming and for being willing to give your remarks and for being willing to take our questions. We certainly look forward to learning from you today. With that, I will hand the floor over to you for your opening statement.
Cool. Merci beaucoup. Good afternoon, Madam Chair and committee members. I am very pleased to be here today to meet many of you for the first time and to provide an overview of the federal lobbying regime, including my office's operations and activities. So the Lobbying Act and the Code of Conduct recognize that lobbying is a legitimate activity, that lobbying should be transparent, and that lobbyists should meet the highest ethical standards. The Act and Code are intended to foster public confidence in government decision-making. As the Commissioner of Lobbying, I am accountable to Parliament, and my mandate includes 3 aspects. En premier lieu, je dois établir et tenir à jour un registre des...
First, I must establish and maintain a registry of lobbyists. As the main tool for enabling transparency of lobbying activities, the registry provides Canadians with information about who is communicating with public officials and about what subjects. On any given day, there are about 6,000 active lobbyists registered. In the past year, they've provided details of more than 13,000 reportable communications. A key strategic priority for the office has been to modernize the lobbyist registration system. As such, we consistently look for ways to improve the registry to make it more user and mobile-friendly.
Of my mandate is to ensure compliance with the Act and Code. My office conducts verifications to ensure that registrable lobbying activities are properly reported and information provided by lobbyists is accurate and complete. Allegations of non-compliance with the Act and Code are dealt with in 2 steps. First, a preliminary assessment is undertaken to evaluate the nature of the alleged contravention, to obtain initial information, and determine whether the subject matter falls within my jurisdiction. Following this assessment, and when necessary to ensure compliance with either the Act or Code, an investigation is commenced. When I complete an investigation under the Code, I must table a report to Parliament. However, when I have reasonable grounds to believe that an offence has been committed, I must refer the matter to a peace officer, most often the RCMP. Offences under the Lobbying Act include failing to register, failing to file a monthly communication report, providing inaccurate information, and lobbying while subject to the 5-year prohibition. In the current fiscal year, I have referred 6 investigation files to the RCMP. And as of today, there are 8 files with the RCMP. When such a referral is made, I must suspend my investigation until the matter has been dealt with. Once this has occurred, I can then complete the investigation and report to Parliament. As of today, the office's ongoing compliance workload includes 14 preliminary assessments and 10 investigations. Les anciens titulaires d'une charge publique.
Former designated public office holders are subject to a 5-year prohibition on lobbying when they leave office. The Act provides that I can grant an exemption from this prohibition based on a limited set of criteria. Last fall, we launched an online tool to assist former designated public office holders who wish to make such a request. Since the beginning of the current fiscal year, I've received 10 requests. 2 exemptions have been granted thus far, and 3 remain to be reviewed. Once granted, the exemptions are published on the office's website. The last but certainly not the least aspect of my mandate is to raise awareness of the Act and Code with lobbyists, public office holders, and with any other stakeholders interested in lobbying. This past year, we focused on updating our communication products and gave more than 50 presentations to stakeholders. This represents more than 600 individuals who now know more about the requirements of the Act and Code. In addition, the Conflict of Interest and Ethics Commissioner and I offered teleconference sessions on post-employment obligations, gifts, and overall obligations for ministerial staff. The office's website remains the main tool to reach lobbyists and the public. We have been updating and redesigning it to make information more readily accessible. A new website will be launched at the beginning of the next fiscal year.
And the effort required to fulfill government reporting obligations is being performed by a very small team of 28 employees. It is important to recognize the unwavering engagement, professionalism, and resolve of the employees of the office who, more often than not, are asked to go well beyond what is required by their position. Creating and maintaining an exceptional workplace is a key priority, and it is important to me that the employees feel valued and understand the importance of their work. In the most recent Public Service Employee Survey, 100% of our employees of the office specified that their workplace prevents discrimination, treats them with respect, and provides the equipment they need to do their job. Over 90% agreed they have the support to balance their work and their personal lives, are proud of the work that they do, and would recommend the OCL as a great place to work. Now, turning to financial resources, the office has a budget of $4.5 million that has effectively not changed since 2008. Personnel costs represent 70% of the expenditures, which is practically $3.4 million. The remaining 1.1 is used to acquire program support and corporate services, including HR, finance, IT, and contracting. Looking ahead, I have concerns about the current budget. Our fiscal reality is attempting to operate with the budgets established more than 10 years ago. $4.5 million may have been sufficient at that time, but today it means there is practically no flexibility to reallocate financial resources, hire additional human resources, or to make necessary investments in an IT system with today's price tags. The registry is a statutory requirement and is vital for transparency. Constant investments are required to ensure that the registry remains up to date with evolving IT and security standards and with the necessary enhancements to improve accessibility of the information. I have recently taken steps to secure additional funding for the coming years by submitting a budget request to the government. Should we get this funding, we will hire additional employees with expertise in IT and information management to ensure the registry remains secure, reliable, and easy to use. Enfin, je ne peux pas conclure sans
Finally, I cannot conclude my remarks without mentioning that the Lobbying Act has been up for statutory review since 2017. I've developed a targeted number of recommendations to enhance the federal framework for lobbying. These recommendations are values-based, aimed at enhancing transparency, fairness, clarity, and efficiency. Should the Lobbying Act be reviewed, I am ready to share a summary of my recommendations or a more comprehensive document detailing the rationale for each of them. Madam Chair and committee members, thank you, and I welcome your questions.
Any questions?
Thank you very much, Ms.
You're
Mélanger.
welcome.
With that, I will move to questions from the members, starting with Mr. Barrett. You have 5 minutes.
Okay, thanks, Madam Chair, and thank you, ma'am, for your testimony today. I had the opportunity to meet with you before to hear about your work that you do on behalf of Parliament, and appreciated that and appreciated hearing from you today. So thank you very much. You mentioned in your conclusion that there is a statutory review required of the Lobbying Act, and 2017 is fast approaching. And that you have and that you do have recommendations in mind. Now, are you this committee has a full we'll fill up our agenda with lots of different items, and I'm just wondering if you'd be able to give us an idea about the scope of the type of the recommendations that you would make.
Certainly. When I appeared on my nomination back in winter of December of 2017, I was asked to be prepared for a ledge review by the spring of 2018. So I've been working really hard for the last 2 years to come up with some recommendations. And experience helps, because the more I get along, the more I think of other things. What I've done is gone through the recommendations that were done back in 2012 and what the committee had gone through and had recommended. And I decided to take a value-based approach. So the values that I've enunciated, so transparency, efficiency, clarity, and fairness. And decide, because there's different things that can be recommended. And I've come up with really 11 recommendations that would really enhance those aspects. And they can really be put in two categories, some with respect to registration and some with respect to compliance. So with registration, the first one that everyone knows about, and I've said it in this committee before, is eliminating the significant part of duties threshold. Very difficult to apply, difficult for organizations and corporations to know when they've met the 20% threshold. If you look at the different charges that have been laid, it's always been with consultant lobbyists or lobbying while prohibited. It is difficult for them to interpret, and therefore very often they possibly over-report, or I investigate and then, it's 15%, 13%. That is a difficult one. What I highly recommend is that there would be, it's transparency, it's registration by default, with very clear criteria, and if you fit in those exemptions, then you wouldn't need to register, because of course we need to have a balanced approach as well. And interestingly, if you may or may not know, British Columbia has just adopted a number of new recommendations, and they have gone the approach, and their law will be in force on May 4th, which May 4th, I don't know if they chose that specifically for a reason, but what are they doing is a registration by default with less than 6 employees, 50 hours in a year, then you do not need to register. My recommendation would be, and I don't know if you want to hear my recommendation, but I will keep going, less than 6, likely about 8 hours in 3 months. I found a full year before having to register is too long. I would highly recommend that within 3 months, if you meet the threshold, you register. And if you ask for more than $10,000, you should be registering. So that's one aspect. The other one is the monthly communication reports. Right now, they have to be oral and arranged by anybody other than the public office holder. To me, for Canadians, who organized the meeting shouldn't matter. And whether it's arranged in advance should not matter. Those 1-hour conversations while you wait for your plane together should matter. And to me, that's an important one. And who's in the room while the lobbying is occurring should all be named. So that's another example of a recommendation.
Okay, well, yeah, thank you. Thank you very much. Who's in the room? That's a key question that should the committee take a further look at this, that I think is one that I find very important. Compliance statistics. Mm-hmm. Is there a move to disclose compliance statistics? How many investigations have been you've undertaken? Mm-hmm. How many complaints have been referred to you? How many you have found on your own, and how did you find them? That type of reporting, I don't believe is currently in your annual report. That level of detail, is it?
The how many I've opened, how many I've closed is definitely in my annual report. How many I've self-initiated versus how many I've received complaints about, that is not in, but I'd be happy to proceed to that. I'll tell you, and I'm going to throw this number out, and I might be off by a little bit, but I would almost bet that 90% are self-initiated.
Okay. Oh, that's yeah, and so I think that would be very interesting, and also help inform us, particularly when there's budget pressure.
Yes.
The work that you're undertaking, it certainly would make a case for an expanded scope. Should that be the case? How much time do I have left, Madam Chair?
1:30.
Okay, thanks.
Oh, I'm so sorry. 30 seconds.
Okay, well, I can't get much done that time. I guess my last question is, in digitizing, you said that having more resources available to you would be helpful. All of these reports are available online for the public, like your annual report.
Yes, absolutely.
All right. Thanks very much.
Yeah.
It's fine for my time.
Moving over to Ms. Briere.
Bonjour, merci d'avoir accepté.
Thank you for having accepted our invitation, and thank you for your presentation. In your annual report, you explained, and I quote, that we updated the orientation figures on the way of diminishing conflict of interest led to preferential political and gifts. This includes preferential access, political activities, and gifts. Your updates replaced Rules 6 and 10 of the previous guidance with regards to conflict of interest and gifts, and this was replaced respectively with Rules 7 to 10 of the new guidance, which concern preferential access, political activities, and gifts. Could you explain the reasoning behind these changes? And more broadly, how do you see the lobbying rules and the rules to prevent conflicts of interest working in parallel?
Okay. Je vais commencer par votre première.
I'll begin with your first question. There's no rule that has been replaced. The ethics code exists, and I can't change this without giving you a copy. So the rules, Rules 6 and 10 still exist, but these rules have guidelines to assist the interpretation, and these are the guidelines that were updated. In the context, first of all, I was new, but also in the context of the fact that there was going to be an election. So there is a rule on political activity, and I wanted to make sure that this was fully understood by lobbyists. So the rules have not changed. I simplified and I made clearer the examples where a conflict could have been determined, and lobbyists did appreciate these guidelines that were updated. A lot was cut down, but it was made more simple. Now, in your second question is to see how lobbyists can prevent conflict of interest. Rule 6 is a general rule, and it asks lobbyists to be careful in all their behaviors, to not act to put the individual listening to them in a conflict of interest situation. Examples 7 to 10 are specific examples, so to not give gifts. If there's a political activity that helps for election, they cannot go lobby, to not use interpersonal relationships to their advantage for lobbying efforts. So these are rules to prevent that lobbyists would put you in a situation that could lead to tension or to conflict of interest, a tension between the public and the private interest. And so these changes were well received. Yes. Thank you.
Non, c'est bon, j'en ai une autre. Toujours dans le...
Yes, still in the annual report, you state that the Office of the Commissioner of Lobbying enables transparency by helping the public, journalists, and researchers and advocacy groups understand the information they find in the registry, clarifying reporting requirements, and identifying the best way to obtain information they are seeking in the registry. Could you give us more information about the ways you help users of the Registry of Lobbyists understand the information they find in it and improve their searches? Last year, if I recall, we had 8,200 requests from the media, from university professors, from students, from lobbyists. Many people who call us to try to understand how this register actually works, to try to find tools on our website. And I was saying that our website needs to be updated, and we're working on it. It wasn't user-friendly. And this is how we help them. And we have 3 advisors that answer the phones, and they answer emails. They try to help people to find information on the register. So the register includes lobbyists, who they met, and on what subject. And then they can make reports. We do a lot of presentations. We have done 50 to date this year, 70 last year. We We almost never refuse, so this affects us a little bit. But yes, we make a lot of presentations and a lot of awareness raising. And you said in your presentation that the website was going to be revamped and it would be updated. We're not going to lose any information. So we were about 3,500 pages. We went to less than 300. The information was scattered. So what we try to do is to be more succinct and not repeat information and to create less pages. So we're trying to use a user-based approach. So this should be ready by April the 1st. I hope so. Thank you.
25 seconds.
Oh, okay. Well, thank you very much for presenting. I'm a new member too, so I really appreciate this opportunity to learn a bit more about your work. You mentioned that the former designated public office holder are subject to a 5-year prohibition after they leave their office, and there's a set limit of exemptions. I just want to know a bit more about the exemptions, and also does this rule apply to members and also member of the Senate as well?
Yes.
Just for a moment here. Mr. Dong, we will come back to you to do your question period in just 2 seconds, or in just a moment, I should say. But right now, I'm going to turn the floor over actually to Ms. Gaudreau.
Oh.
Monsieur Dong.
Mr. Dong, I'm new and I have a lot of time before me. I offer you my time to ask your question. That's nice.
So thank you very much, my great colleague Cross. But yeah, just help me to understand these two general questions.
When lobbyists lobby public office holders means really think about any public servant, including yourself, your staff, senators, and their staff. They need to register. But there's a subset group of that, designated public office holders, which includes yourself, members of parliament, senators, obviously ministers, they're members of parliament, and their staff. And when they leave office, you're subject to a 5-year prohibition on lobbying. The exemptions under the Act are extremely limited. They're really for people who have been there for a short period, students, individuals that really had only administrative duties, those that had any power, decision-making power, the exemptions are not for them. But students in minister's office are designated public office holders, so they will often be the ones asking for an exemption when they leave office.
Okay. Thank you, Madame Blanchet.
Yes.
Thank you.
Hello, Mrs. Bélanger. Thank you. I'm new. I have many questions. I'm going to ask the main ones. Today, you're with us to describe your role, but I would like to know what will be the role in the next few weeks, over this next session. We will see you just once, or will we have regular interventions during our committee work? I'm always available for the committee. Anytime you would like to have a discussion, I'm available to meet the committee. I sent you all a letter with information. I'm prepared to meet your staff. I know that you're very busy. So with regards to interaction, normally, once documents have been tabled on the budgets, normally I'm invited back in May. But otherwise, I am fully available to meet with the committee. Thank you. My next question, when you spoke to additional funding, I'm really aware of this. There were issues. You worked on the website. You were trying to maximize this, and I have concerns with regards to access to information. I'd like for you to explain to me how do you explain this request for extra funding and what this will be used for, and how we can remain vigilant with regards to this privacy and protection of privacy. What I can tell you is that the risk that personal information be disseminated or be breached, it won't. I'm from access to information. This is something I believe in, and I always will invest the necessary money in the register to ensure the integrity of the information and that it is protected. This being said, the more money that I put in the register, well, there is not a lot of funding to allow me to fulfill the rest of my mandate. So my budget request is for 5 additional staff members. I'm asking for $780,000 extra per year to hire 5 people, especially for information management and management of the register, and also to pay for the updates of equipment. Okay? Madam Chair, how much time? Can I ask another question? I have 10 minutes. Oh, wow. Okay. I need to choose. I think that we will have the opportunity to ask more specific questions. I'm trying to find questions that might interest everyone on the committee. Ultimately, how does it work? You were saying earlier on that you had some files right now, and some files that were completed, some that were underway before you arrived in this position. What is the link that we have as parliamentarians at this standing committee? I want to know what my role is as well. So what happens if some issues are well, yes, there are reports that will be tabled possibly, but if I'm investigating on the ethics code, for example, and if my investigation is completed, I make a report to Parliament. What I can tell you is that complaints, there are much less complaints than under the Act. As to whether people were in the register, not part of the register. And so most of my investigations have to do with the Act. And when I say that I investigate, I do an investigation. I interview people, I collect documentation, and I write up reports. And these reports are then sent to the RCMP, and they're not sent to the Parliament. And I've sent 6 in the past year. And this is, normally there were 2 or 3 a year. This is a record. I sent 6. And 1 from the prior year. There was one that was prepared by my predecessor. If something is suspended, well, the RCMP does the work that they have to do, and to see if there has been an offense that was committed. Thank you.
Mr. Angus for 6 minutes.
Thank you, Madam Chair. Thank you, Madame Belanger, for coming. It's excellent to have you. I'm very pleased. As long as it's not coming off my time, you can laugh all you want. Thank you for coming. I commend your work. And certainly there are many lobbyists who come and try and meet. And you listed the reasons why you would investigate them for failing to report, failing to live up to the code. One of the elements is under Section 6. And the Code of Conduct for Lobbyists is not to place public office holders in a conflict of interest. I think that's one of the key ones. So on February 14th, 2019, I wrote to you after Mr. Dion announced that he was launching an investigation into whether or not the Prime Minister breached the Conflict of Interest Act. February 19th, you responded, and I'm very pleased you did, and said that you were going to look into it. So did you do an investigation?
What I will tell you is that I look into everything that comes in. I cannot give you any further comment simply because I am required by law to keep everything private, in particular in the event that I would not want to jeopardize the integrity of any police investigation.
Well, I thank you for that. I guess my concern is, and we've had this only a few times, where a serious matter is brought before lobbying or with a conflict of interest, and there's a finding, and your predecessor, Ms. Shepherd, used to find lobbyists having contravened the act, but sometimes then the public office holder wasn't. So I find that on August 2019, Commissioner Dion found that the Prime Minister had broken Section 9 of the Act, which I think is very specific because it was to improperly further the financial interests of another party, that being SNC-Lavalin. and that he said that the authority of the Prime Minister and his office was used to circumvent, undermine, and ultimately attempt to discredit the decision of the Director of Public Prosecutions, as well as the authority of Ms. Wilson-Raybould. So I know you can't say whether or not you carried out an investigation or not, but it seems we're in a very odd situation that the person who put the Prime Minister in this position, or the people who did, are not, there's no report, there's no statement, there's no reference whether it was turned to the RCMP. We don't know. So if you found it sufficiently serious and you forwarded it to the RCMP, would you not at least make that statement known, or that you had initiated an investigation? Like, was there an investigation, and what were they found in compliance or not?
I cannot confirm anything in relation to investigations that I conduct. And it's really because that I need to ensure the integrity of all investigations, including that of the RCMP. And I can tell you that if I'm doing an investigation under the code and under the Act, and that I have to forward all the information that I've obtained under the Act to the RCMP, I must also suspend the one under the code, because I can't be talking to all the same witnesses at the same time as the RCMP.
Okay, thank you.
I can, if I may just add, I can tell you as well that it is somewhat as well frustrating for you for me not to be able to confirm anything. It is also frustrating for me and the employees of my office not to be able to share the extensive work that we do. Everything is being looked at very thoroughly, and I can only ask you to trust that the system is happening in accordance with the Act as it should, and when and if I have an opportunity to report to Parliament, I will.
Well, I really appreciate that, and I don't want to make it more uncomfortable for you. I guess my concern is having a sense of whether an investigation has begun. Mr. Dion, there's some outstanding investigations he hasn't reported back on. I would assume because we knew he began one. Some of those cases, they may have been moved on to the RCMP, so it's not for me to ever ask him. But if we don't know if an investigation has begun, we don't know if an investigation has been concluded. So would that be something that we would need to look at changing in your role, so that we can have some clarity and your office has some clarity, because it's about public confidence at the end of the day?
I think that if the Act were changed to be able for me to confirm whether or not I've started an investigation and whether I've completed, but I don't complete those investigations that I send to the RCMP. I suspend them.
Right.
And then I wait for them to do something, whether it send it back to me or whether they have a charge. And only when that is done, if they send it back to me, then I could report to Parliament. Or if they charge, for example, the Carson file.
Right, yeah.
I ended up ceasing that when it was returned. There were charges. He was found guilty.
Yeah.
I'm not going to report to Parliament on the
exactly.
same matter. So that is the way the Act is set up right now.
I only have 30 seconds left, but I want to ask about the ability to maintain an investigation, because sometimes the RCMP level for actually moving on something like the Carson case, there are levels that have to be very, very high to meet for the RCMP to step in, because it would be so explosive. But there would still be, in other areas, clear contraventions of the Act. So would you suggest changing the rules so that you are able to have the discretion to decide whether or not to continue an investigation or to hold it so that you could finish it off? Because it seems once the RCMP have looked at it, and if they don't move on, it seems like, well, things are done, but there are sometimes still clear questions about the Act that need to be protected.
If the RCMP sends the file back to me, I will likely still report to Parliament on many of the files that I have dealt with in the last year. Even if they decide not to proceed with accusations, what I would do is simply report to Parliament what I had done and what I had found. That's what I would do. But it hasn't come back to me yet.
Thank you for that.
I would also just add, if I have 1 second,
Certainly.
I think having a spectrum of sanctions would help as well, because
Yes.
right now everything is an offense under the Act to be sent to the RCMP, when in fact, you're correct, not all files are created equal, and there might be ones that we could simply do a public report with AMP's prohibition on lobbying and not necessarily an offense under the criminal code.
Thank you.
Thank you. Monsieur Gord, for 5 minutes.
Présidente. Merci, Madame Bélanger, d'être ici. C'est toujours un plaisir de vous recevoir.
Thank you, Mrs. Belanger. It's always a pleasure. Now, the lobbyists are very active on the Hill. They do a lot of lobbying with us and also with the civil servants. So are there any subjects that you've noticed where there was a lot of lobbyist representation? And does this raise any red light if you have a lot of representations of lobbyists on the same issue? Is this something that's happened over the past year? Well, I would say that as soon as there's a hot file, if you look, for example, a few years ago, there was legalization of cannabis. So, of course, we saw a heightened lobbying effort. Health, the environment, industry, economic development, all of these issues are, and we see this in the media. We see that there's a lot of interest in these issues. There are issues that are in the interest of the public, and you discuss this. If there was no lobbying, then I would be concerned, because then I would wonder why is this being covered by the media and there's no lobbying? So I'm pleased to see that there's people that lobby, but that it is registered. So is there a lot of lobbying at the Privy Council? The Privy Council, I think that they are the third or fourth department, that they are the busiest, third or fourth. House of Commons, number one, because it is an institution. Generally speaking, industry, science, economic development, innovation, science, number two, and then it's the Privy Council, the Prime Minister's office, always third or fourth. So you have the lobbyist register, but you have the register on all the subjects? Yes, yes. This is what's indicated on the register is not only the subject, but also they have to add detail on the subject, what was discussed. It's not minutes, but they do have to specify what kind of representations are made by the lobbyists. In my experience, oftentimes it's budgetary measures, and it's rare that it's to save taxpayers' money. So is this to justify expenditures that might happen in the future? I don't know. I'm not privy to the discussions. I can tell you that the register does indicate the subject of the discussions and also says if there's an ask, a monetary ask. The more things that I see in the register, well, I know that there's more transparency, but the quality of the lobbying, the access, that is not of my purview. It's not my mandate to manage that. Now, to see if they're meeting with you with regards to funding, this is a criteria, is a subject. Is it the greatest percentage of the subject? I don't know, but I could provide the information. Yes, it would be interesting for us to know the percentage. Financial measures, other measures. In my experience, people who meet with us, it's very rare that they're bringing forth measures to save money for the taxpayers. Oftentimes, it's to justify either compensation, future requests. When I was in government, it was the opposite. They wanted for the government to do things, and when we're in the opposition, to make sure that the government is going in the right direction. Well, yes, I'll find statistics. We know that lobbyists are being paid by firms. And what I find really disturbing right now is that those that have the means to pay lobbyists are heard much more than those that don't have the means to pay. And they would have the right to be represented. They come and see us. And we know that these lobbyists, they're earning between $300 and $700 an hour. This is not the average Canadian. Is there any way for you to provide access to other Canadians, those that don't have the means? Well, lobbying is done with you, so it's up to you to decide who you're going to provide access to. I make sure that when you provide access, that it's in the register. Right now, I don't have the mandate to determine who has access. That's not my mandate. I could never manage all your calendars and determine who has access to what. There's no, anyone who's paid for lobbying has to be registered. And I don't think it's up to me to determine or to decide if the person that is not paid, that they have access. So if the person is not paid, can they register? No, they don't have to register if they're not paid. That's true. because the register for lobbyists is there really to regulate a profession, the profession of lobbyists, people that are paid. This is a Pandora's box. So if you can lobby without being paid and be paid in another way. Thank you.
Okay. Moving to Mr. Dong for 5 minutes.
I think I'll start with I'll give it to Brenda to answer the question, and then with that remaining time, I'll give it back to my honorable colleague across the floor, and my gratitude for giving me the time to ask the question. Thank you.
Well, thank you, Han. Justement, merci beaucoup, Madame Bélanger.
Thank you, Mrs. Bélanger. Thank you for your presence here today. What I find really interesting is the way that you've worked with the commissioner regarding conflict of interest. Here at the committee, we also work, and I don't have all the French words, Office of the Information Commissioner.
Previous experience with Privacy Commissioner and of course, as you mentioned, the Conflict of Interest and Ethics Commissioner. So I'd like to learn a little bit more. Are you working with the other commissioners? And if you have worked with offices such as the Office of the Auditor General, for example, it seems to me that some of the things that you're doing, and I know how difficult it is to kind of set up shop and having to run all the systems and so on. But certainly, and perhaps there can be some synergies found in working with other agencies.
Absolutely. The agents of Parliament, we meet regularly. We're a good group of colleagues. I work with the Conflict of Interest and Ethics Commissioner. I signed an MOU with him very shortly after I arrived so that we can share really outreach activities, which we have done quite a number of. We even did some YouTube videos, and we've done a lot of teleconferences together so that both sides hear the different perspectives, either from the lobbyists or from the decision makers. So I've done a number of presentations with him. The Office of the Privacy Commissioner is actually the organization that holds our server, our registry. So it ensures the integrity and the respect of personal information. So I do have an MOU with that organization. It costs us about $200,000 a year, but that's taken care of. All of my services for finance, for contracting, for HR, whenever we want to hire somebody, for the finance and the contracting are with the Canadian Human Rights Commission. They provide that service, and we have an MOU with them. So I haven't done anything with the Auditor General, and I don't know if he would be open to that. But right now, I've got the resources that I need to do more of the corporate side of the function.
Very good. And so on passe le temps là, pour notre collègue.
Okay.
I'm trying to understand. We have 4 commissioners, and what I've been observing is that there's a lot of collaborative work. We were talking about funding. We were talking about, well, depending, as such and such a commissioner will take care of a part of an issue. So is your working relationship with the other commissioners? And do you think that eventually, because we're here to help you, do you think of restructuring? Could you work together more, especially if you have a need with regards to staffing? I have 2 questions, in fact. What can we do to help you? And secondly, what collaboration or what opportunities for collaboration can exist? Because it's very, very closely linked. Access to information, lobbying register. I'm understanding what this means, but yes, obviously, we all have distinct mandates. Can we collaborate more, cooperate more? Maybe. We would have to think about it. Within the provinces, some of these offices are amalgamated. Now, as to see if there are positives and negatives to this, the committee could invite the commissioners and to see if it would be advantageous or not. I can tell you that any opportunities that I have to cooperate or to work jointly with them, I do so. because we're small, but I do have a separate mandate from them. So it's not easy to combine this. We all have the requirement to keep confidentiality of information. So this places limits on what we can share as well. I have time?
Ben, je vous remercie, vraiment.
Thank you, and I believe that we will work together again, that we'll reach better understanding. When we speak to confidentiality or privacy, it doesn't mean that we're going to reduce privacy if people work together. No, there can be ways of doing things that might be different, and we'll work together. Thank you.
Eric, for 5 minutes.
Thank you very much. Thank you very much, Madam Chair, and thank you very much to the Commissioner for coming. And I guess the first question, I hope to get a few questions in, so I'll ask you to keep your responses fairly short. But this is I as a new member, and I know there's a number of new members around this table. Would there be 2 or 3 quick reference points that you in your role could share with MPs in this committee in ways that we can make sure that we are doing our jobs most effectively to ensure that you can do your job most effectively?
Quick reference points for your committee. I don't think so. I think I appreciate these invitations. I feel like we work quite in isolation, and so having the opportunity to share is absolutely welcome, because I need to know that you know what I'm doing, that I am working hard, that my team is working extremely hard, and I do not want to make it look like we're in an ivory tower or something, not doing anything. So as often as you want to invite me and to hear from me, it will be my pleasure to come. Otherwise, I have a very discreet and very focused mandate, and I think if we maybe in the future we'll have an opportunity to work together if there's ever a legislative review a little bit more closely, but otherwise I think that having open discussion and communication is the best, really.
Well, I appreciate that, and certainly that answers my question, so thank you very much for that. On your website, and as I've reviewed your mandate and some of the information that you've sent, I'd just like to read into the record a quote that I think is very, it highlights the important, and it's found on your website, and it's that the purpose of the Lobbying Act is to ensure transparency, accountability in the lobbying of public office holders in order to increase the public's confidence in the integrity of government decision making. That I think is a fairly accurate description of your overall mandate, kind of succinct into one statement. And I would just ask for any comments that you might have on how you as Commissioner, your role in ensuring that Canadians can trust the institutions of Parliament, trust that their government is not subject to undue influence and that sort of thing. And I'm not sure if you were here for part of the debate before, but this is something that's top of mind, and certainly I heard a tremendous amount about during the last election, and continue to hear a lot about from constituents, is that we need to have confidence in our democratic and governmental institutions.
Yes, well, I'm a great believer in access to information and transparency. I was in the access world before. I continue to promote transparency in everything that I do as much as I can. I reach out to lobbyists a lot, and I am watching everything that goes on. And when I said earlier that likely 90% of the work that I do is self-initiated, so all I can do is try to continue to instill the integrity of how lobbyists do their work. And quite frankly, there are 6,000 lobbyists that are registered. Under the code, ethical conduct, I am not receiving many complaints. I am not really observing much. There is a lot going on, for sure, but at least Canadians know about it if they go look at our registry. Now is how do I reach out to all Canadians to make sure they know about my registry? Well, little baby steps. I am trying to go as to meet with anybody who wants to meet with us. I am in universities. We try to use social media, and all we can do is word of mouth, reaching out to you, and and hopefully people will understand that the role of the registry and of the lobbying regime overall at some point. And really it helps to contribute to the the integrity of decision making.
Yeah. No, I appreciate that. Now if I could ask how much time I have left.
Sorry, you have 30 seconds.
Perfect. Okay. So I guess my final comment would be is that lobbying is often known as a dirty word, and as it's so important that this registry and the investigations that you undertake help Canadians ensure that they can ultimately trust government. And we talk a lot about trust because often it's the headlines and whatnot that speak to when trust is shaken or broken. So I would leave you with this final comment. Thank you for the good work that you do, and for your role in helping ensure that Canadians can ultimately trust our public institutions, and specifically in regards to your mandate as the lobbying commissioner. So thank you very much for appearing before us today.
Thank you.
Shanahan for 5 minutes.
Yes, in fact, I'd like to give my time then to Greg Fergus.
Madame Shanahan, Madame la Présidente.
Thank you, Madam Shanahan. Thank you for the second opportunity to speak with you, and I would like to say that I really loved our first meeting. For all my colleagues that don't know, before I was an MP, I was an in-house lobbyist with the Canadian Universities Association, and one of the things that I was responsible for my team, it was to lobby MPs in the 41st Parliament, and we've had this discussion. One of the things that I insisted on with my team and everyone, even volunteers throughout Canada that came to work on the interests of universities, I insisted that everyone register, even if it was not necessary. I found that it was really preferable to provide more information than less. And one thing that I did notice is that it was quite complicated, especially for volunteers, for people who are not used to doing lobbying. Sometimes if it's 5% of their job, I would like to know, is there a way of simplifying the registration process so that Canadians can benefit from a true update for the situation when we speak about lobbyists who lobby politicians or other officials? Well, there's different ways of simplifying this. There's simplification for those who have to register. One of my recommendations is to harmonize. If you're a corporation and organization, the criteria are different, and I think that they should be the same. With regards to registering, there was a two-step process. You had to sign a contract, send this, and this has been eliminated. Now you go to the system, into the system, and you work with someone who's registering you. So over the past year, we have simplified the registration process. And now we've transferred everything with WebForce. I'm not an IT expert, but we are making sure that it is accessible by phone. People who have to register had to go back to their offices, enter into the system. Now they'll be able to do this from their mobile phone. So we're very aware, and we did a review, client services. We did a study, and they were saying that once we know how it works, it's easy. But it's to get there. That's hard. And so we try to improve the process. We're making baby steps, but we are listening, and we are making progress. That's fine. Thank you. Second question. With regards to what you said with regards to your presentation before the committee, and that you would like for us to include conversations that would be held if you're waiting in line for the bus, or if you're waiting in line in an airport. I'm not trying to make this more complicated, but once again, I remember in my former life, before politics, because for 32 years now I've been here in this region. I'm one of the rare people who has been here for so long in Ottawa, and because I've been here for so long, I've met with many lobbyists. Sometimes we will speak and meet somewhere, and I don't know if I started the conversation, if they initiated the conversation. I don't really know anymore. And sometimes it's detailed, sometimes it's not, sometimes it's irrelevant. If it's detailed, sometimes I say, okay, remember that you need to register this. Once again, I'd like to know if we're making things more complicated than they should. Are we going to create a huge huge burden of work for you and your team? Well, if something is being created, it's because something is happening that should be registered. If it happens a lot and it's not registered, then we have a problem. And you're correct. I think that we're going to simplify things. Who initiated the conversation should not be relevant. If you're waiting in line, and if you ask, oh, did you have something to ask? Or if he says, oh, listen, I have something to ask. Communication, if it has to do with nothing relevant, that's not important. But if the person says, oh, can you support me for a request for $10,000 or $15,000, well, that's lobbying. Now, if it was organized ahead of time and who initiated the conversation, well, that makes it more complicated. But as soon as a lobbyist makes a request, it should be written in the register and it should end there. So I hope that simplifies. I'm sorry.
Madame Belanger, thank you so much for your time. Thank you for being willing to answer our questions and engage in conversation with us today.
Thank you.
To all the members, thank you for your thoughtful questions and interactions. And with that, I will call this meeting adjourned.
Thank you. Vous pouvez me la poser la question, je vais vous répondre.